Hi, welcome to the next session of 401k Culture. This session is called Fiduciary Forensics, and it is actually a synopsis of a large certified course, 3-hour certified course that we offer called Fiduciary Forensics. This is kind of a summary of it. The Fiduciary Forensics course that we offer in full certifies individuals to act as fiduciary forensics analysts, and it takes a deep dive into ERISA, the ERISA laws, defined benefit plans, and state laws under the Uniform Trust Act and other things. But welcome to this session of fiduciary forensics, and let's take a look at what we have. Let's try to simplify who's a fiduciary. Not an easy task because it can be confusing. In many cases, the same party often holds multiple roles. For example, in most plans, the sponsors may be both the named fiduciary and the 316 plan administrator. So let's take a look at what ERISA says about 401k plans specifically. 401k plans are subject to all ERISA fiduciary responsibility provisions. If you read something about ERISA and fiduciary responsibility, it applies to 401k plans. The general requirements of prudence apply across the board relative to 401k plans. Due diligence, performance monitoring, and ongoing review are required. Plan fiduciaries will be held liable for imprudent investment practices. So to simplify, who's a fiduciary? Well, it could be the partners, the owners, the directors of the company, the officers, individually the trustees, could be the investment advisors, the investment managers, could be the brokers, the plan administrators, basically anyone who has any discretionary authority or control over the management of the plan and or management of the plan assets will be a fiduciary. What are the responsibilities of fiduciaries? Well, they have important responsibilities subject to certain standards of conduct because fiduciaries act on behalf of the participants and their beneficiaries. In that way, they function like trustees, holding the assets of the plan in trust for the participants and the beneficiaries of the plan. They must act solely in the interest of the plan participants and their beneficiaries with the exclusive purpose of providing benefits to them. They must carry out all their duties with the skill, prudence, and diligence of an expert familiar with matters. They must follow the plan documents, unless, of course, the plan documents are inconsistent with ERISA or they're inaccurate. They're required to diversify the plan investments so as to minimize the risk of large losses, unless under the circumstances then prevailing, large losses minimization wouldn't be appropriate. And I really can't imagine a situation where it wouldn't be appropriate to minimize large losses. They're required to pay only reasonable expenses of administering the plan and investing its assets. And at all times, they're required to avoid conflicts of interest. In addition, the fiduciary is also responsible for selecting investment providers, the investment options, the funds, the ETFs, for monitoring their performance, for firing them and changing them when necessary. Some plans, such as most 401k or profit-sharing plans, can be set up, though, to permit participants to choose the investments in their accounts. And there may be certain requirements on those investment options that are provided by the plan. But if the plan is properly set up to give participants control over their investments, then the fiduciary is not liable for losses resulting from the participants' own investment decisions. So what about liability? Well, if we follow the flow of liability up to this point, all fiduciary liability begins with the named fiduciary. There's no reduction in the named fiduciary's liability by delegating to a 316 administrator or hiring a TPA, because chances are the TPA, third-party administrator, doesn't want to be a fiduciary, and the administrator, if not a TPA, is usually the sponsor, at least on, legally is the sponsor on paper. So liability for the management and disposition of the assets is often delegated to the individual trustees, who are partners, owners, directors, and such of the sponsoring company. Now, those trustees can hire a 338 fiduciary, which gives them some relief from liability with respect to picking the investment options of the plan. The sponsor, otherwise, if they've not picked the 338 fiduciary, they essentially delegate liability to itself. Consider the fact this is the area with the most exposure to liability. This is a primary area of concern. Liability for breach of fiduciary responsibility is harsh and it's personal. Under the statute, any person who breaches any of the responsibilities, obligations, duties imposed upon fiduciaries shall be personally liable to make good to such plan any losses to the plan resulting from that breach. The employer, the sponsor, can still be responsible, though, for, among other things, picking the plan investment options or picking the right investment manager to manage the plan. They have that responsibility and they have that liability. So selections of investments offered under the plan still might remain an employer liability issue. And they have to be careful about 404C. They're responsible for compliance with 404C, and they have to make sure if they elect 404C that the investment options offered fit the 404C requirements. Employers and sponsors may be responsible for monitoring the performance of the offered choices. Did they pick the right service provider? Did the service provider pick the right funds? They're also responsible for communication of information to participants and beneficiaries, whether that information is provided by they themselves, the sponsor or the employer, or provided by the service provider. They're also responsible for, as we've said before, participant education. And lastly, to reiterate, they're responsible for compliance with the 404C requirements, because if not, liability comes back in a big way. So if that isn't met, then they're going to wind up seeing the court. The problem in the marketplace is that most employers are totally unaware of their fiduciary responsibilities. So I'm going to contend that it's your responsibility, or at least it's the financial advisor's responsibility, to educate the employer, the plan sponsor, on their fiduciary duties and ways that they can mitigate those fiduciary responsibilities. Because as we've been saying all along, liability for breach is personal liability and it's stiff. Plus there's a 20% penalty, civil penalty, in the amount recovered due to a breach, such as a prohibited transaction. And qualified plans must pay 15% a year if they violate the fiduciary responsibilities. So fiduciary responsibility, the biggest task in 401k plans, it also creates the biggest opportunity for financial advisors. So let's take a look at the article that's provided below that gives a little bit more detail from Fiduciary Forensics, and then we'll move on to take a look at the problem and the opportunity.